sideshow they're trying to put up. They're trying to get everything in, everything that has nothing to do with the facts of this case. They're trying to bolster people by making them experts. Again, just tender into evidence whatever that legal classification was as a business record exception. Not saying that we agree with it, we will object to that, but it's a business record exception because it's part of classifications. When you go into the jail, you get fingerprinted. That young man or woman that grabs your finger and rolls it across is not a fingerprint expert. That is a technician that takes fingerprints. A person that asks you, what gang are you in? What is your name, date of birth, and social security number? That is not an expert. That is a technician. That is an intake officer. And that is a very honorable job. It is a risky job. Anybody that puts on a badge every morning and goes to work, whether it's in the streets or at the jail, is risking their lives every day. Does not make them experts. Stop trying to bolster all this testimony that could come in other ways. They can prove their points in many other ways by classifying people as experts. Just on this particular set of motions, we are dealing with, we've been here for a week, going into way after the court closes on these medical experts. I was never approached and asked. I mean, I know I'm not the one, the shot caller, but we can stipulate to all these medical experts. You don't need to put in, I think the one of the experts that came in yesterday, I love his answers. Like one is, he's a medical expert and he asked me, have you ever been published? No, he's not an academic, but he's still an expert. Have you had any awards? Nothing beyond my paycheck, but he's still an expert. But you know what? This is what the trial is about. They are trying to get in all these people that are not experts. And if you mix them in with the actual experts, with the medical examiners, with the GBI forensic chemists, if you put them all there, then they all sound very important, but they're not. Respectfully, Mr. Hall, you're not an expert. And we ask the court that you do not allow them.
To the commentary addressed to the witness during Mr. Chavez's argument.
All right, I'll sustain that particular, that point.
My apologies, Your
Okay,
Honor.
all right, okay, all right. Thank you, sir.
Thank you, Your Honor.
All right, anybody else?
All right, he did a
Wish
great
to go in terms of
job.
argument before I let the state go ahead and finish up.
Shout out to Minash. Thank you.
Mr. Sumner, I'm just going to bring this up because we've heard what the state's going to say. I mean, we heard it all day yesterday.
Not yet, but
Well, no, we heard it all day yesterday. We read this. We heard the script. What I'm saying is they're going to harp on the fact that this gentleman said that his training gave him outside information that the regular everyday person doesn't have. The testimony that he said
well,
was
it's kind of inconsistent on that. So
agreed. But the testimony that came from this witness was on different cases being prosecuted, which has nothing to do with what's going on here, and specific crimes that are being investigated. So the state's going to get up and say there's all this outside information. I just want to remind the court, put on the record, this witness didn't tell us any of that outside information that applies specifically here. So he is not an expert. The information that he's providing is not relevant to any of the however many co-defendants are still left in this case. So I just want to make sure that's clear because I'm pretty sure we're about to hear that again.
all right.
Yes, Your Honor. Mr. Johnson for Mr. Eppinger. Your Honor, as it relates to this particular expert, looking at the Daubert factors, what that was brought up earlier, we can say that his techniques are not reliable in any way in this matter. He testified that majority, and I asked the question specifically, I'm not disputing the fact that he has received some training, but he testified that majority of his determinations and classifications comes from information that probably would not even be admissible in court. He comes from the hearsay statements of individuals on the phone that he cannot confirm the veracity of, and also statements that were written inside of a jail cell that he cannot say exactly who wrote them or anything else. And as Ms. Bernard brought up, all of these conversations take place when individuals are in custody, and most of them are represented by counsel, so would not possibly be admissible anyway. So, and also, Your Honor, as it relates to his classification and knowledge of the gangs, the district attorney who presented yesterday got up here and stated that Georgia, Atlanta has a gang problem. So to act like the public does not know about or have any knowledge about the gangs is kind of disingenuous. The state is going to allege through this trial that there's a great intersection between the gangs and the hip hop community. So that in and of effect gives a wide range of individuals who would have knowledge about these things that we discussed as it relates to the markings, the identifiers, and all the stuff that he uses in his classification. This is not something that the public does not know about. There are 10-year-olds on the internet right now who are watching this online who know about all of these markings and things of this nature right now. So to say that he has some kind of specialized knowledge that the public would not be able to understand during the presentations of the state's course is somewhat disingenuous. And the fact that that information is based on evidence that will probably be inadmissible in court also does not make him an expert in this case.
Shout out
And
to
for
the
those
chocolate
reasons, Your Honor, we
solution.
do not believe that he should be qualified as an expert in gang identification at the DeKalb County Jail.
All right.
Thank you.
Anyone else? All right, Madam, Ms. Rosenwasser?
Yes, Your Honor.
Thank you to the chocolate solution. So what do y'all think? Y'all think he's going to be admitted as an expert, or is he not an expert? Put yes if you think he's an expert.
Your
Put
Honor,
no if you think he's
I'd
not
like to
an
start my
expert.
argument with a quote from the Second Circuit.
What do you think the judge is going to say?
Although he had never been qualified as an expert witness, even the most qualified expert must have his first day in court. That's out of United States versus Locascio, LOCASCIO 6F3D 924. That's the Second Circuit, 1993.
I
Your Honor.
want to clean this up.
This gentleman is absolutely qualified to offer expert testimony in classification of gangs at the DeKalb County Jail. So I'd like to start by responding to a few of the objections we've heard, particularly that according to the defense attorneys, gang knowledge is something
Thank you,
that the
Lisa.
general public has. Now, Your Honor, I don't dispute there are members of the general public that are affiliated with gangs, that know gang members, that are aware of gangs in the state. And certainly the General Assembly is aware that there's a gang problem, but that doesn't speak to the general public. I can tell you, Your Honor, when I started in the gang unit, I had a family member say, wait, do we have a gang problem? Just because these defendants are in that life and that there are people in the public that are familiar with gang tattoos and are familiar with gang lingo or gang expressions, that does not apply to the general public. We are in a big county, Your Honor, and to say that everyone in the public is aware of this specialized gang knowledge is just absolutely completely specious argument, Your Honor. This individual testified, Investigator Hall testified, that he has specific information that he learned through training at the GGIA, which certainly not everyone can go to. And he has learned, he's one of only 2 people that can do the classifications at this jail. And if he makes a mistake, people can die. And while Mr. Chadha wants to take credit for Mr. Dorsey keeping the jail safe, I think it actually speaks as circumstantial evidence the fact that Investigator Hall is reliably applying the methods, that there hasn't been a murder at the jail, that he has been able to correctly classify over 50 gang members so that there are not these incidents. The reason, as the court's aware, there is a charge in this case involving Mr. Dorsey attempting to arrange that type of thing. This investigator's job is to stop that through his classifications. That's what he does. The fact that no one has died speaks to the fact that he's good at his job, not that he's bad at his job and he doesn't know how to do it. There is circumstantial evidence that he's reliably applied the principle and methods. And Your Honor, the question specific to, who wrote the report, who listened to exactly what, who made the jail call, that's all questions that go to weight, not to admissibility. And they are more than welcome to cross him at trial. They are more than welcome to call their own expert and say, he doesn't know what he's doing, he's wrong, my expert. I'm ready for battle of the experts, Your Honor. We can certainly do that, but that does not mean that this expert is not qualified. Your Honor, I'd like to point the court to a few gang cases that are out of the 11th Circuit, and I don't even remember which hearing I did this in yesterday, but I think I gave the court some of these sites yesterday, but I'd like to provide them again. United States versus Augustin is a pretty seminal case out of the 11th Circuit, and that's AUGUSTIN. That's 661F3D 1105. That's a 2011 case out of the 11th Circuit. And that was one of the first cases to look at gang expert testimony in the 11th Circuit. So, as I quoted yesterday, the 11th Circuit found, we note that Federal Rule of Evidence 702 does not define an expert in a narrow sense. And the court found substantial experience that Agent Young had with respect to street gangs, we conclude that the district court was within its discretion in determining that Agent Young was qualified to give expert testimony about the organization in question in that case. Here, we have the same situation. Investigator Hall has a ton of experience. All he does all day is make sure that he doesn't mistakenly classify someone, because if he does, people will die. He has looked at gang lingo. He has looked at gang writing. He has looked at gang literature. He has attended gang trainings. He has attended over 100 hours, even if he might not be great at math, but he's sure great at gangs, Your Honor, and he knows what he's talking about. He is aware of the different ways to classify these individuals when they come into the DeKalb County Jail. That is experience that he has. That's what he's gained from not only his training, but his years there. And as he testified on redirect, he's interacted with inmates. He knows them. He couldn't have got his current job.
Let me just stop right there. Did y'all see the black lady auntie or pass that note signal to the white girl? Watch this. Watch what she does with the folder. Look at this. Look at this.
But his years
Say
there.
this.
And as he testified on redirect,
Say that.
he's
I caught him passing
with
notes.
inmates. He knows them. He couldn't have got his current
Hey,
job
look how she
if he
leaned
hadn't
back.
spoken to inmates, if he wasn't aware of them, if he hadn't learned how to have conversation with these folks so that they will be honest with him and they will tell him what gangs they're affiliated with, and he's able to obtain that information. That's his whole job. And for the defense to claim that this is something that the general public is aware of, I think that's just absolutely misunderstanding the reality of the situation. While the general public certainly might be aware, okay, yeah, there's Bloods, yeah, there's Crips, sometimes they have tattoos, they're not gonna know. I didn't know until this morning that 7 and 2 are Bloods lingo. That's something I didn't know. And I'm gonna guess it's something that most of the people in the public don't know. Maybe people here do, but Your Honor, that's not gonna be something that somebody just coming out of their house one day and coming to jury duty, they're not gonna know that. And that is exactly the type of thing that we need expert testimony to show, because the general public is just not gonna be aware of those intricacies that someone is going to learn from years doing gang investigations, speaking to gang members, listening to thousands of hours of jail calls, and basically having these interactions day to day with gang members, Your Honor. This is the exact type of experience and knowledge that's necessary. That's why we need to have these experts to explain. So it makes sense why we're doing this, and we're not just calling someone off the street to be like, yeah, I think he's in sex, money, murder. No, this is someone who has understood that and can make the classifications and can explain why they've made those classifications. In United States versus Wilson, that's another 11th Circuit case. That was 2015. That again goes to the qualification of a gang expert.
What's the citation?
I'm sorry, Your Honor, that's 634 Fed APPX 718. Now, in this particular case, the court found that where the defendant testified about his, I'm sorry, Your Honor, where the detective testified about his experience and his training, and that how he had spoken to multiple gang members and about the gangs themselves, and showed the connections between the gang and why that was related to the case, the court found that that was going to be sufficient. And I want to point out something specific about Wilson that I think is important. At Penn site 727 in Wilson, the particular gang expert that testified in Wilson was actually admitted as a general gang expert. This particular gang expert didn't actually have any direct information about the appellants in the Wilson case. He just testified about the background of the gang. And the court found that that was acceptable. The court found it didn't matter if he did not have personal knowledge if any of the appellants in that case were in the gang. It was that he was able to provide that specialized background about the Bloods gang in that case based on his training and experience and his the fact that he knew about how these gangs worked, his history, the traditions about gang membership, the distinction between West Coast, East Coast Bloods. He was able to explain statuses in the gang. He was able to explain tattoos in the gang. And that's a lot of what we heard today from Investigator Hall. And Investigator Hall even does have that boots on the ground knowledge, but I wanted to bring Wilson to the court's attention to explain that it's not a question of specifically, okay, it's whether he's an expert in this particular field. What he knows or does not know specifically about Cordarius Dorsey or what he's
Part
done.
of it is application though.
Absolutely, Your Honor, but I wanted to point that.
Daubert does require that, when you have training, with non-scientific specialized knowledge, you still has the testimony still has to be based on data, reliable principles, and the experts reliably apply the principles to the facts in this particular case.
Yes, Your Honor. So, we wouldn't call him if he had no knowledge of DeKalb County jails or any classifications, but I wanted to point the court to Wilson to show how far that is stretched, just to show the court that this is not a situation where he's in no way involved. Wilson absolutely applies. And the court in Wilson specifically found that this was something that was likely to assist the jury because it shows the import of the evidence in evaluating the alleged gang activity underpinning the conspiracy charge. Obviously, we have a RICO conspiracy here, and we also have Mr. Dorsey charged with a gang activity count as a result of his actions in the DeKalb County jail. So that is directly related, Your Honor. And the court found that this was highly probative, and here's why. They said evidence of the appellant's membership in or affiliation with the blood gang tended to make the prosecution's theory of the case more likely. So it was admitted in this case. Your Honor, another case out of the 11th Circuit that I'd like to point the court to is United States versus Lobo Lopez, LOBO-LOPEZ, 468 Fed APPX 186. That's an 11th Circuit case from 2012. And in that particular case, an individual was qualified as a gang expert. That individual testified that he had been assigned to a gang task force. That individual testified that most of his job focused on one of the gangs at issues. He testified that he'd gone to training at various conferences about gang activity. He testified that he had been involved in gang investigations and that he participated in surveillance of gang members approximately 50 times and had interviewed 50 gang members during his career. The court affirmed the admission of this expert testimony. The court found Rule 702 does not require that a court rely solely on an individual's education to qualify him as an expert. Rather, the text expressly contemplates that an expert may be qualified on the basis of experience. Here, and I'll just say the expert's name to make it make sense. Here, the expert testified to extensive experience in investigating the gang, surveillance the gang, interviewing the gang members, and training with law enforcement on this gang and another gang that was related. Accordingly, we cannot conclude that the district court abused its discretion in qualifying this individual as an expert on that particular gang. Specifically, the court found that the expert's testimony, quote unquote, shed light on the various rules, terminologies, and methods of the gang, and they concluded that the testimony was proper and that it should be admitted, and that the court properly admitted it. And there's a lot of cases from other states too with the same other circuits too, and I do want to note that Rule 702 doesn't just confine courts in this state to looking at the 11th Circuit. It actually says specifically to look to all federal courts and other states. So briefly, Your Honor, United States versus Ledbetter, that was out of the 6th Circuit. And the district court in that case, a notable line that I want to point out is that an individual was qualified to testify as a gang expert, where the court found, notably this line, the district court sensibly noted that it could not imagine too many people having more credentials. So essentially, he said he's one of only 2 people that knows how to do this. He has the credentials, he has the experience, he has done this, he knows how to do it, and if he does it wrong, people will die. So he has a real incentive to do it right. And the fact that nobody's died speaks very, very highly to his abilities. Your Honor, additionally, specifically, the court found in that Ledbetter case that the gang testimony helped the jury to determine whether the charged gang was a criminal enterprise.
What's the citation for Ledbetter?
Yes, Your Honor, I'm sorry. That's 929 F3D 338. That is a 6th Circuit case from 2019, and the spelling of Ledbetter is Ledbetter.
Shout out to
And
Jay.
additionally in that case, and this is at pin site 348, the court said, as we said in
I'll
United States
explain all
versus
this to you
Johnson,
guys
which
in
is
a
another
second.
case.
I'll explain it all.
Courts generally have permitted police officers to testify as experts regarding drug trafficking as long as their testimony is relevant and reliable. There are innumerable trades and practices that employ their unique devices and codes that may mean nothing to the untrained observer, but may speak volumes to a maven qualified by experience or training. So I think that's what we have here, Your Honor. Contrary to the defendant's statements, while maybe their clients or someone else may have detailed inner workings about how a gang operates, your average layperson in Fulton County certainly does not know that 2 and 7 are Bloods lingo. They don't know that a 5-pointed star tattoo can go for the Bloods. They don't know this. This is exactly the type of stuff that he has learned only from years and years of interacting with gang members at the county jail and classifying those gang members. This is not something that you could take any old person off the street and just do. You couldn't. I've been working on this case for, 7-8 months. I think I do a pretty bad job trying to classify gang members because I do not have that same experience. I don't know what he knows, and I'm essentially a gang prosecutor, and I don't know that. So what he has to offer is way beyond the ken of the average juror, Your Honor. This is exactly the type of thing that experts need to inform the jury about and explain why they're able to classify folks in the DeKalb County Jail. Your Honor, United States versus Hankey, Hankey, that's 203 F3D 1160. That's a Ninth Circuit case from 2000. And in that particular case, it just again says the relevant reliability concerns may focus upon personal knowledge or experience. And it also says what I like to point out in this case at Penn site 1169. Here, the witness had devoted years to working with gangs, knew their colors, signs, and activities. He heard the admissions of the specific gang members. He had communicated and worked undercover with other gang members. This type of street intelligence may be understood as either remote or hearsay, but FRE, Federal Rule of Evidence 702, works well for this type of data gathered from years of experience and special knowledge. That's exactly what I've been saying, Your Honor. He knows things that I don't know, and I'm sure a juror doesn't know. Maybe one juror might, but I can tell you, Your Honor, this is not the type of thing that every juror is going to know. There are jurors out there that might not even recognize what the legislature has, that we have a serious gang problem. They are going to need to be educated, and he can provide that education. That's exactly the purpose of expert testimony. Again, Locasio, I provided the court to that site earlier, and that again says, just because an expert's never testified before doesn't mean he's not an expert. Sometimes we have to be the first ones to pave this ground. And I think, Your Honor, it's important to note, of course, that 702, as applied to criminal cases, is brand new. So we're doing a lot of these. If it sounds like we're doing stuff for the first time, it's because this is a brand new statute and we're having to make sure that they're qualified in a way that maybe we were not having to before. So that's why we're here today, Your Honor. And again, I'd also like, in Fourth Circuit, United States versus Thomas, 490 Fed APPX 514, a gang expert was qualified. Here it just said, this is important about the factors. The Daubert factors simply are not applicable to this kind of testimony from a gang expert whose reliability depends heavily on the knowledge and experience of an expert rather than on the methodology or theory behind it. Here, the extent of the officer's knowledge and experience was sufficiently probed, and the district court did not abuse its discretion. I'd also like to point the court to a case called United States versus Archuleta, ARCHULETA 737 F3D 1287. That's out of the 10th Circuit in 2013. Specifically, what I'd like to point the court to in that is that in that case, the court found that the average juror is unlikely to be aware of those facts. Those were facts referred to structure and activity of the gangs. That's exactly what I'm saying here today. Although there are some people that might know that, that's absolutely not knowledge of the average juror, Your Honor.
A lot of your argument, though, Ms. Rosenwasser, focuses on, on testimony that might be for a gang expert and for some of the factors that the court considers. I'm not saying, but you're going, do you have anything that's more recent that our circuits have done, the 11th Circuit or any other circuits post enactment of our 702 and the Daubert requirement?
Well, Your Honor, the federal courts were operating under 702. So the Wilson case I gave you was Your Honor, was 2015. They were doing 702 before we were. We essentially just adopted their rule. So all of their holdings are going to be applicable here. And so a lot of these cases are fairly recent under the federal court. So I don't have anything from after we adopted that in 6 months ago.
Do you have anything from any of the federal circuits that interpret 702 or Daubert since then? Or recent pronouncements, like after 20, let's say after 2020, 2021, 2022?
Your Honor, I can certainly provide that. The court could be a moment, but what I want to, the law hasn't changed for the federal circuits. It's only changed for Georgia.
I understand that, Mal. I understand it. I'm not saying it isn't, okay, but there are some other civil and criminal cases that appear to interpret when you have a federal cases, that when you are talking about non-scientific areas of specialized knowledge. So the inquiry goes back to Kumo, and it says that the Daubert factors don't necessarily may not apply to testimony. It depends on the knowledge and experience of that particular area.
Mm-hmm. Yes, Your Honor.
And it references Hankey which is a Ninth Circuit case, but it's you look at Daubert, Kumu, Hankey, 702. And for example, I'm looking at MedCorp versus Airmark Sports and Entertainment LLC. Entertainment Service LLC. It's out of the United States District Court of Arizona, April 23rd, 2021. It's a slip opinion. 2021 Westlaw 1597897. And it talks about Daubert analysis is applicable to testimony concerning non-scientific areas of specialized knowledge, Kumu. However, the Daubert factors may not apply to testimony that applies to knowledge and experience of the expert rather than a particular methodology, Hankey. Finding the Daubert factors not apply to police officers.
I'll explain all this in a
testimony,
second, guys. Give me.
They just talked about that issue. But an expert qualified by experience may testify
Thank you,
in
Christopher.
an opinion if his or her experiential knowledge will help the trier of fact to understand the evidence and determine a fact and issue, as long as the testimony is based on sufficient data, is a product of reliable principles, and the expert has reliably applied the principles to the facts, 702 in Daubert. So, and of course, it does, the advisory committee that talks about amendments to 702 talks that vigorous cross-examination, presentation of contrary evidence, and careful instruction on the burden of proof for traditional and appropriate means of attacking shaky but admissible evidence under Daubert. But even though that's a civil case, it kind of gives me some roadmap in terms of what I'm supposed to look at in terms of non-scientific evidence, which this would be.
Yes, Your Honor. I believe Your Honor stated the factors exactly as I've stated them. I think that is the analysis. I think, and I've just been trying to provide the court.
Well, how do we know he applied these correctly to this particular facts and circumstances? And I haven't heard any testimony about that. That's kind of, I've only heard one thing. I've heard that he made a statement to another, and as Mr. Jimenez mentioned a little earlier, you may have some foundational issues in regards to that, but I'm struggling whether or not he applied it to applied it correctly to Mr. Dorsey. Now, You haven't told me and you needed this evidence for some other reason other than classification, and it hasn't been brought out in terms of that, but that's my concern with Mr. Hall.
Okay. Your Honor, I believe that, first of all, as I've stated, we have circumstantial evidence that he's reliably applied his methods generally, and the fact that no violence has occurred, that he's been doing the classifications correctly.
That's a stretch.
I mean, Your Honor, with these experts, it's different than when you have, for example, okay, a scientific test, you put it in, did it show cocaine?
Let's just say, as a general proposition, I'm glad that people who are in custody haven't been harmed in DeKalb County. But the fact that he's classified may or may not necessarily go to that particular issue. So.
Well, Your Honor, I think the fact that Mr. Dorsey, his ability to discuss that Mr. Dorsey is a member, that he was classified as a member of sex, money, murder, and how they did that classification, I think that's absolutely how he applied his methods, and it was reliably done, and that can be inferred by circumstantial evidence. And it's different with these gang experts because they're essentially testifying about, they're not testifying about the results of an experience.
Did he testify that Mr. Dorsey was a member of sex, money?
Your Honor, yes, he testified that they classified Mr. Dorsey as a member of sex, money, murder. That was my belief about what he testified to. He also testified to that he listened to that he heard communication showing that Mr. Dorsey was a high-ranking member in the jail. That was the testimony that I recalled. And Your Honor, if the court would like me to provide additional case law that
I don't need more case law.
Or if the court would like further questioning, we would have no problem with the court reserving ruling and revisiting this later should the court wish to recall him at a later time if the court feels that this is not ripe yet.